Pete, you're a beautiful little monster. Yeah. I'm glad I have you on the phone.
Hello, my name is Irwin Ironstone. I also go by Irwin Eisenstein. Today, what I'm going to talk a little bit about is a writ that I wrote to the United States Supreme Court questioning my rejection by the Florida Supreme Court of my request to become a Florida lawyer. Now, the writ itself, I don't know if that's going to come through, but it's available on Irwin Ironstone, academia.edu, Florida Board of Bar Examiners. If you look that key up, it'll give you a First Amendment writ before the Supreme Court. Florida does not. And the reason I say Florida does not is although the writ was rejected, my belief is that the Florida process violates First Amendment and also due process. Violates the First Amendment because it restricts speech. I was not allowed to report improper behavior, or what I believe is improper behavior, by the General Counsel of the Florida Board of Bar Examiners. It also prevented me from getting due process, and all of that is outlined in this writ. Now, I could go over the first few questions, and maybe that's what I'll do. I'm having difficulty because I just had cataract surgery, so things are not always as clear as I would want them to be. The first question that I asked was whether the rules governing confidentiality of the Florida Board of Bar Examiners violates the First Amendment when they regulate speech based on content, place prior restraint without limits, and they ban almost all speech that is critical of a branch of government. And that branch of government would be an agency, the Florida Board of Bar Examiners, that is controlled by and is regulated by the Florida Supreme Court. Now, I believe that there are a lot of things that happen to me that probably happen to a lot of other people. I think they lost papers and then charged me with not submitting papers. They took 4 years or almost 4 years before I had a formal interview, and the only reason I believe I had the formal interview is I said that if I didn't have a formal interview, I was going to write a writ of mandamus. And a writ of mandamus says to the Florida Supreme Court, hey guys, the Florida Board of Bar Examiners is not hearing my action on a timely basis. There are lots of other errors and things that went on. For example, the discovery process was not run by the attorneys in the Florida Board of Bar Examiners. It was by Michelle Gavagni, who is the executive director, who isn't a lawyer, and some of the requests for discovery were outrageous. I'm sure they do this as a method to prevent people from finishing and from actually being interviewed. The second question that I have is whether the Florida Board of Bar Examiners denies due process when it refuses to submit any positive information before the board on behalf of the applicant, and the panel and before the hearing are confidential. They prevent the applicant from filing formal complaints against members of the board who violate rules of professional conduct or law. Now, those were the two questions. Now, next, I go into the table of contents, and I'm not going to go into the table of contents too deeply, except to say that the first issue relates to the First Amendment and the restrictions put on me by the Florida Supreme Court, saying I couldn't report any of the information about the actions of the General Counsel to the Florida Bar. To me, that's a restraint of First Amendment. The other issues relate to due process, and that too is summarized in the first few pages here. When it refuses to submit any positive information on behalf of the applicant and prevents applicants from filing formal complaints against members of the board who violated rules of professional conduct. And obviously, what I'm going to do is just skim through this because it is online and it's a nice writ. Although it wasn't accepted, very few writs are accepted. The number of writs that are paid for that are accepted are probably around 3% or even less, fewer than that. I didn't expect it to be accepted, but I think that what I wanted to do is point out so many of the different issues related to the way the Florida Board acts in an isolated, restricted manner. You can't record the hearing. There were errors in transcripts. It's about time that the Florida Board allowed someone to record with either video or with audio so that others who have to go in front of the board in the future have an idea as to what to expect. And I'm going to just skip along. Anytime you have something that's confidential, it doesn't serve the public. The person who should make the determination as to whether a hearing is confidential is the party who's being questioned. In other words, they accused me of not having reasonable character and fitness, and I had letters from 15 or 16 people, some of whom have known me for years. One or two were from teachers, a few were from lawyers, there was one from a judge, and all of them didn't question my honesty, trustworthiness, or anything else. Yet, the Florida Board didn't believe that I had acted properly. And I think one of the reasons is I'm overly critical of members of the legal profession. I think that I've been in front of judges who lie. I've been in front of lawyers who lie, and no one holds them accountable. And that happened during my hearing. Now, what I'm going to do is just point out some of the headings. This one is on page 20. Florida seeks to punish speech which has traditionally been recognized as lying at the core of the First Amendment. And Florida has done this in the past. One of the cases is Buttersworth versus Smith, where they prevented someone from talking about his experience before a grand jury in Florida. That one was overturned by the U.S. Supreme Court. Many of the rules governing the Florida Board also violate rules of professional conduct. Now, there are areas where people should be allowed to talk about their rights and the First Amendment. Florida doesn't give that alternative method. And what I was going to do is just go over the many errors, and just some of them, that resulted in what I believe were violation of rules of professional conduct by the executive director, not the executive, the general counsel of the Florida Board of Bar Examiners. And what I'm going to do is skip ahead and just go to some of the due process issues, because they didn't allow me to use the entire record on appeal. They didn't even send me the record that they had submitted to the Florida Supreme Court on appeal. Each of those is contrary to what one would expect to have in a fair and open hearing before the Supreme Court of Florida. In my case, that didn't apply, and doesn't apply in anyone else's case either. There were, in fact, records that the Florida Board received that they never wanted to show me. They say they were secret and they weren't available to me. The rule itself says that if they would be available to me, then they should make them available. That never happened, so they used their rules very selectively. I noted that there were problems in the transcript, where it was clear the transcript was doctored, and the general counsel obviously made errors, and they weren't really errors, they were omissions and failures to make entire transcripts available to the board. Now, when that happens, he has a chance to correct it after the fact, and I raised some of those issues because he refused to make those corrections and notify the board. Okay, now I'm getting to page 36, and it's a formal hearing. The general counsel raised new issues that not part of any prior specifications, misstated material facts during the hearing and afterwards. The general counsel accused me of the unauthorized practice of law. Now, in Florida, if you're going to accuse someone of unauthorized practice of law in a civil action, that violates the rules of professional conduct. Now, the general counsel accused me not once, not twice, but 3 times. And when he was later asked to explain it, he said it didn't have any difference. It didn't make any difference. In fact, what he said, and this is quoting him, the applicant has testified, and some of his witnesses have testified about some pro bono work that he has done. Although I would submit to you that some of it may be somewhat questionable because it sounds like he's doing legal research for pro se litigants who are not lawyers, and so on. I don't claim to be an expert on UPL, that's the unauthorized practice of law. That seems to be pretty close to that. So effectively, he violated rules of professional conduct by accusing me of acting criminally in a civil action, and he did it more than once. In his response to a request for reconsideration, what he did is he said, assuming arguendo, those issues were of concern in the applicant's case. They are not. Of course they are. If you raise issues before a group, it's effectively charging me with the unauthorized practice of law, which is criminal. Can't do that in a civil action, yet he did. When I tried to report it to the bar, they wouldn't accept it. They said, well, the court determined that he was correct, but they don't know what the court had available to them or not. So it's sort of an indictment against the entire process where the bar also isn't capable of reviewing those people who are higher up on the hierarchy. In any case, the following due process issues were raised before and against the Florida Board and its General Counsel. They include the age of many of the actions reviewed in the specifications against the petitioner. Most were 15 or 20 years old and don't reflect what I know now, although I still find that if something is wrong and someone lies, whether it's a judge or a lawyer, I'm going to accuse them of lying. Law school doesn't change that. I may have to tone my statements down. The other thing is they knowingly presented false and misleading information in the formal hearing. They said I failed to include documents. They lost the documents. That's something they do all the time, and no one holds them accountable. With me, they had a pile of documents that were probably 6,000 pages high. And they did that, I'm sure, to delay the hearing and to ensure that I couldn't be approved. The other thing is, I had a transcript going back 20 some odd years where it said, you know, a judge in a family matter in New Jersey in 1994, said I threw papers off the counsel table at the court. That's a lie. I had a transcript and it was in the record where I tried to hand a single piece of paper to the bailiff, and in handing it to him, the single piece of paper fell to the ground. What it was a piece of paper that was left out of my divorce settlement by my ex's attorney. I tried to present that to the judge, but he was so pissed off at me because he signed the divorce that he said I threw papers at the court. A lot of nonsense, and it was proven in the transcript. The general counsel never raised that to the board of bar examiners even after the fact, which to me means he lied or misstated material facts to the board. The other thing that happened is there were conflicting statements about what the procedures at the Florida board were. I tried to examine the general counsel for general procedures. He wouldn't let me. Not only wouldn't he let me, he refused to testify about those procedures, and then accused me of being antagonistic because he knowingly knew things that were wrong in the process. He's close to the process. He knows that documents are lost all the time. He knows that the executive director frequently makes comments that suggest she's functioning as a lawyer. That would be the unauthorized practice of law. Yet, he didn't say a word about that. I don't know when that's going to change, but it certainly is a violation of rules of professional conduct if he knows someone in his organization is functioning or giving advice as if she is an attorney. The other thing is the Florida board was critical of evaluating public service or rehabilitation. It was arbitrary. I had helped hundreds of people. Most of them, I got letters from 16 to 17 of them who knew that I was helping other people. I never charged the person. I taught the person how to do legal research online. I never said I was an attorney. And I taught them, and I edited some of their papers and made suggestions. That's not the unauthorized practice of law, according to the United States Supreme Court. But Florida is different from the rest of the country. They don't follow rules of the Supreme Court. And the cases are in the writ that I've submitted here. They lost papers that were submitted by me, and then said that I had not submitted the papers and made false, misleading, or statements lacking in candor, when in effect I was more truthful than they were. They refused a petition or a subpoena to examine the general counsel. I had written probably around 35 pages, and they dismissed it with a half-page statement with a check mark. They don't want their process reviewed in the public. They don't want it reviewed by anyone else because there are so many holes in the process. They use their process to deny a whole bunch of people access to the bar. At one point, I'm sure they were running up costs. They asked me to retrieve 20,000 pages. And what was funny about it is they tried to get these pages from other courts, and when they heard I assumed the cost, they just gave it to me. That would have been $1 a page, and it would have cost $20,000 to retrieve all of this information. The clerk of the New Jersey courts asked me initially, "Are you from the Florida Board of Bar Examiners?" Because, they had called and made this request before. So they did it as a delay tactic. They did it to prevent me from basically presenting everything that I could that was reasonable. They acted unreasonably because they wanted to keep me outside of the bar. It appears that the Florida board was using discovery to delay a formal hearing. Florida Bar test scores expire after 5 years. Failed to reconsider my application, even though what I did is I pointed out that they misstated information. They took a transcript that my daughter had, where she'd spoken and was being interviewed by a judge, and they misstated facts. The general counsel, rather than use the transcript, filled in his own words, and then said, out of the mouths of babes. The fact is, my daughter said I did follow instructions. The fact is that my son, in the same transcript, said I followed instructions. Counsel never gave the entire transcript. He gave 2 pages, and he asked me to read parts of 2 pages, I think 2 lines. But he never corrected his own statements. He accused me of unauthorized practice of law. He lied about what my kids said about me. They said that I do follow rules. And I think I tried to follow or to file a complaint against him, but the bar said, we're sorry, that must have been reviewed by a court. Now, part of the issue is I submitted my complaint to the Florida Supreme Court, so the Chief Justice of the Supreme Court has a complaint. At a later point, I'll probably try to go over that complaint, just as I'm doing now with this writ. I'd suggest getting online and searching for the writ, and I'll give you the keys in order to search. And the reason I'd like you to do that is it shows how Florida refuses to, number one, help the poor, restrict access to help by those who can't afford attorneys, and this has gone on for about 25 years in Florida. The case I remember is Serena Dunn versus the Florida Bar, because at one point the Florida Bar brought charges against someone from helping those who couldn't afford to hire attorneys. Even recently, the Florida Bar put up roadblocks so that people who can't afford attorneys don't get help. There are lots of things that, and I'm going to point this out to the Chief Justice of the Supreme Court, one thing that they could do, and I know they have planned this, but nothing happens with it, is put up specific motions so that people who want to file their motions and can't afford an attorney can use those models to file papers using the template that lawyers and or the Florida Supreme Court finds are acceptable. I don't expect non-lawyers to file perfect papers, but I do expect them to file papers that they can copy. And the other thing that I'm going to raise now, and it appears that there have been changes in the rules where lawyers are now allowed to charge people with sanctions based upon their theory that what they're presenting isn't necessarily correct. I've looked at some of the papers that other people have submitted. The Florida Supreme Court accused me of not filing papers properly. And I responded to that in a writ, and what I find is it's disgraceful because the Florida Supreme Court appears to live in an ivory tower and doesn't realize people can't afford $300, $400, $500 an hour for lawyers. Okay, and I'm going to again say this is Irwin Ironstone, and I'll never be a Florida attorney, but that's okay because I will help and continue to help people by reviewing their papers and not charging for it, and telling them I'm not a lawyer and giving them advice as to how they can do research, because no one in the Florida Supreme Court appears to be doing that. Thank you.
Pete, you're a beautiful little monster. Yeah. I'm glad I have you on the phone.